for the benefit of the BMA members and participants. And today's session is a very, very interesting session, which is of interest to almost everyone, people across age groups, across the society, because in today's time, this is very, very important. That is succession planning, wills and interstate succession, which is being taken by none other than but our dear colleague and EEC member elect, CA Dr. Vishnu Kanhere. If you see on the screen, his qualifications which are mentioned speaks a lot about his achievements in life. And it is my honor today to introduce him. Dr. Vishnu is a practicing chartered accountant, a qualified cost accountant, and a certified fraud examiner with a brilliant academic record, having won several gold medals and awards. He is certified in governance of enterprise IT, CGET, USA, systems audit, risk management, data privacy, and information security. He is an alumni of Sydenham College of Commerce and Economics. He was awarded PhD in management from JBIMS for his pioneering research on valuation, concepts, and practices in Indian industry, covering intangibles like software. He is a fellow member of Institute of Valuers. Dr. Kanere is an expert in taxation, auditing, overseas investments, fraud examinations, information systems, security, system audit, accounting, financial management, costing, management consultancy, evaluation and valuation of intangibles, including TV and cinematic content, computer software, brands, and intellectual property valuations and other intangibles. He has over 30 years of experience in consulting, assurance, and taxation for listed companies, leading players from industry and authorities, multinationals, private organizations, and high net worth individuals. His academic achievements and hands-on working experience reflect a wide canvas on which he operates. Dr. Kanere has a deep insight into macro and micro issues and in the field of finance. He has written the first ever book in the world on software valuation, which is a unique book published by Thomson Inc. He has several publications to his credit, including chapter in book on computer frauds by Ville, published in January 2009. A renowned faculty at several management institutes, government academics, and corporate training programs, Dr. Kanhere has been a key speaker at national and international conferences and seminars on a wide range of topics. Dr. Kanere was an independent director on the board and member and chairman of audit committee of large listed companies. Dr. Kanere is the recipient of prestigious Bharat Shiromani Puruskar awarded by Institute of Economic Studies, New Delhi for the year 2009 for enhancing the image of India through his outstanding contribution in his chosen fields. He has been awarded the prestigious fellowship of Linnean Society of London 2010. Further, Dr. Kanere has been a member of Balanced Card Focus Group and CGET QAT of Isaka, USA, a past chairman of Computer Society of India, Mumbai chapter, convener of SIG on Humane Computing, convener of Interest Group on Security, and chairman of FIRC of ISA, and expert on Security Committee of IT Cell of Indian Merchants Chamber, among other affiliations. He is currently member of Audit Advisory Board of Director General of Audit, Central Principal Director of Audit, Indian Accounts and Audit Department, Mumbai. Dr. Kanere, we thank you for taking out time and spending time with our members. We look forward to an interesting session, and I'm sure the members will have a lot of queries based on your presentation. We look forward to your deliberation. All floor is yours, sir.
Thank you, sir. First of all, I thank Sharma sir for the glowing introduction. Maybe it's a bit longer and larger to larger than life than I expected. But let me plunge into the subject itself. Before I do that, I'm thankful to Kavita Lagate ma'am and entire BMA. Now, of course, I've been a life member all along, and now I have, fortunately, the members have reposed confidence, and I have been elected to the managing committee. So hope to contribute. But today I'll be coming before you in a slightly different role. That is explaining personal succession planning to you. So what I propose to do is essentially succession of individuals happens either with a will or without a will. Either the individual has made a will, which is a testamentary writing, also known as, we'll look into the nuances of it, or an individual could die without making a will, or a will though made may not be found ultimately. So in that situation, the person or a will may not be valid even if it has been written. So in that case, it would be intestate succession. That is a succession where there is no valid will in existence. The succession or how the property devolves on the legal heirs is different in that case, whereas in the case of a will, it will be different. So we will be looking at both these. We'll be also looking at some instruments which are additionally available for planning succession. I can tell you what they are. Like trusts is one vehicle for, you can call it a special purpose vehicle. In the case of those who are Hindus, a Hindu undivided family is another such vehicle, which enable property to be conveyed to the next generation. Similarly, there could be holding companies or corporate entities, but essentially we are currently looking at individual succession planning because the topic itself is so vast. So I'll limit it to individuals. If time permits, I'll just briefly touch upon corporate and other forms, or even trusts for that matters, and HUF. So that will give you a flavor. Maybe it can be covered some other time. So now, first, some fundamental questions. So I'll just see if it is getting, it is. So the first fundamental question which one is faced when one talks of succession, because what is succession? Succession actually means that the person, that is you yourself or I myself, has passed away. So when the person passes away, the life as we know it has ended. So then the issue which comes up is, what is the purpose of life? Before looking at the purpose, that is why we are living our lives and what exactly is our objective, depending on what stage of life you are in and which culture you belong to, we will get different answers, and we will probably get as many answers as there are people whom you ask this question. No two answers will be alike. But before doing this, I want to give you the view, so-called Western view, but it is actually not a Western view, because you might have heard the name of the great Indian philosopher Charvak. Now this Charvak was actually a Gnostic. He did not believe in the existence of what we generally understand as God and as a bigger principle of life and of life after death. So he had put out his entire theory in one small shlok, and he has written texts which run into thousands of pages. But I just recite that shlok for you and quickly give you the meaning. So yavat jivet sukham jivet. Runam krutva ghrutam pibet. So what does the first line mean? As long as you are alive, live, enjoy the pleasures of life. So live a life of luxury, or, be happy with life, enjoy life to the fullest. Runam krutva ghrutam pibet. Now, in those days, probably ghee was, or clarified butter was something which was a luxury and which was equated with enjoying life. Only the rich could afford, or those who are enjoying life could afford ghee on their food. So the second part of the first line is Runam krutva. Runa means debt. So borrow money, but enjoy life. Ghrutam pibet means literally have ghee. In short, enjoy life with fully borrowing. But why? The second line explains it. Bhasmi bhutasya dehasya. Because in Hindus, among Hindus, cremate the dead. So after you're passed away and you're cremated, it becomes ashes. Bhasma means ash. So bhasmi bhutasya dehasya punaragamanam kutaha. Where is the return? There is no return after your body is consigned to flames and it is burnt and you turn to ashes. In short, do whatever you want, take maximum debt, because later on you don't have to account for it or you're not answerable to anyone. Once you pass away, you no longer exist. So this kind of a thought, something akin to what Westerners do. Future income also they borrow against, use credit cards, multiple credit cards, take debt which takes 20 years, 30 years to pay off. In fact, there is reverse mortgage also. What does that mean? That you mortgage your property during your lifetime and you will never be repaying that debt. You will get equated monthly installments as money, which is even permitted now in India. In fact, I think about 4 or 5 years back, this concept was introduced in the budget of reverse mortgage, and all nationalized banks provide this. So in case, especially what happens is an old person is there, he doesn't have source of income, and currently today, if you see 3%, 4% is the rate of return which we are getting. Those who have a fixed income because they have retired and now reached the age of 80, 82, and they need to live, they might need expenses on medical, treatment and things like that. Where will they get the money from? Suppose they have no dependents or the dependents are not looking after them. If they have property, they have to live in it. They can't let it out. In such case, they can do a reverse mortgage, approach the bank and say that, look, my property value is say 1 crore rupees. So give me monthly a certain amount, say 50,000 rupees. And later on, after my death, if my legal heirs are there to claim it, well and good, they will pay that whatever is the outstanding with interest and get the property released from it. In the alternative, the bank will auction the property. Whatever money is realized, they will settle the debt along with the interest, and the balance money they will give to whoever is the legal heir or nominee which you have mentioned in your agreement in respect of the bank. So this is something which actually is the extreme, that you even kind of monetize all your assets. Now, however, when we look at our Indian way of life, what do? Our purpose of life is to have a good family, raise a family, have children. Both the spouses, now it is double income, no kids initially, and later on there could be kids. So we live for, basically we want to educate our children, we want to make them achieve something in life, and we also want to provide for them. So often it is found that, especially when one reaches the age of 55 plus and tries reaching 60, because today 60 is not a retirement age. But at that time, one starts realizing, oh, what am I running around for? Eventually, because if I don't enjoy even at this late stage, then that he or she will start feeling that when I decide to enjoy, by that time, I will not be in a position to enjoy myself. So probably the initial days, as they say, 4 dharmas are there. So the first stage goes in acquiring, learning, education, skills of life, equipping yourself to running the life or becoming something. The second stage, that is the Grihasthashram, goes in establishing yourself, establishing a household. Probably in modern terms, it means that you buy a car, you buy a flat, so you can live well, you have all the amenities, you settle down in life, you save for the old age and future. So you start doing that. So your best part of your youth as well as middle age goes in that. And then you start thinking of, you have a family, you raise it, you look after their education, their marriages, various things. You also provide for medical emergencies. You also enjoy life by traveling. Now, having done all this, then you start thinking, what will I do for the future? So instead, one must think of all these questions. I'll park those questions to you. But out of all the answers, one of the answer is that you work and earn, although also for yourself, you also do it for your next generation. Therefore, you want that your assets are preserved and they are passed on to the intended beneficiaries. They don't go to people whom you don't want to give it to, or well, they are not frittered away after your death, or they are not taken by people who actually are not entitled to it according to you. So then how do you ensure that even after your death, the way in which you intend that your assets should pass is perpetuated? Now, the only proper way of doing this would be, so this is what you often work for. Spouse, children, parents, siblings, family, friends, people who work for us, a special cause or an activity close to our heart. Some people work and give their life for an institution, for society, for others, rarely for ourselves, but we also do it for that. Having said this, if you have identified any of the first earlier parts, that is other than ourselves, then you will need to have some kind of a document, some kind of a writing, which will perpetuate your will. Will means your wish, that what is to be done with your property after you pass away. What is to be done with your income if you are getting an annuity after you pass away. So it is not just immovable property which can be disposed of by a will. It is movable property also. It is your annual income which you get also. Now, when we are looking at all these, whether movable or immovable property or source of income like an annuity which is coming in, question which immediately comes to the mind or arises is that, well, why should I be making a will? Because I'll nominate. No, now often in the bank account you have nomination. In your society you have a nomination. So you have a nomination everywhere. Moment you have a nomination, why do I make a will? So let us first now look at a few slides which tell you the reasons for making a will. Because there are other ways in which you can ensure that property goes to the intended recipient. Then why go through the bother of making a will? Because the moment you make a will, when we come to the procedure, you will understand that you have to write it down. It can't be oral. Having written it, it has to be executed in a certain manner. It has to be proved or established in a certain manner. So all this requires some amount of effort and some amount of care to be taken. We'll look at that, of course. I think, yes, you have put a message. So you can decide how your estate is distributed. If you don't do this, if you don't make a will, then even if you have given the nomination, so this is the first thing which I want to clarify. The Supreme Court has decided, and I don't want to clutter you just now with the case laws, but it is very well known that a nominee holds the property only as a trustee for and on behalf of the beneficiaries. So a nominee can be somebody who is not a beneficiary at all. He may be a family friend, he may be a confidante, or a person whom the person who has made the will believes in or has full faith on. So he thinks that yes, this person will do justice to and hand over the property to my legal heirs. So what happens when a person's nomination is there, either in a immovable property, that is your cooperative society flat, or in a bank account? See, moment you have a nomination, if you give the death certificate and the nomination, prima facie that entity, that is the society, has to transfer the property to the name of the nominee. That is the only thing which is assured because of that. But beyond that, the nominee does not become the beneficial owner of the property. The ownership rights of the property, as the Supreme Court has clearly held, remain with the actual beneficiaries. Now, if there is no will, then if a person is married according to Hindu law, that is a marriage with rituals, which is ultimately solemnized by a priest and then registered, of course, with the register of marriages. but it is not a marriage under the Special Marriage Act, where the registrar has to give a notice and it is done. It is not done that way. So if this is a regular marriage, which is normally called as a traditional marriage, the Saptapadi, that is the 7 Sat Fere and the exchange of the Varmala, if both these are there done, then it will go according to the Hindu Succession Act, that is Hindu law. So in short, if a person is married under the personal law, then whatever is the personal law applicable, either Mohammedan law or the law in the case of Parsis, that is how it will pass. Now, in the case of those who are married under the Special Marriage Act, before the registrar or the sub-registrar of marriages, then in that case, it will pass according to the Indian Succession Act. So we'll look at succession under both these, so you will get an idea. So therefore, if you want to give your property to particular people and not according to the succession law applicable to you, then in that case, you must have a will. If a will is not there, then prima facie property will pass according to the succession law applicable to you. The second thing is the arrangement is as per your wish and more equitable. Now, equitable will be based on your view of the facts. So often we find, for example, in our case, I have, yes, definitely me as well as my spouse. She's a pediatric neurologist. She's a doctor. Both of us have made wills. We have left the property equally to our children, whether they are, the son or the daughter, we have left property equally to them. Some people feel that the daughter marries and goes into another house. That is at least mostly by and large what happens. So she joins another family. So their thought is slightly different. They think that, well, a greater amount should go to the son, perceived as a legal heir. So let me tell you, what I have observed over the last 30, 40 years of my practice is that daughters take more good care of the parents than actually sons, because they are more able to do so. They are able to devote time and they are able to ensure that they can do that. But well, I'm not into what or how you should do it. I'm only saying that where you envisage an unequal distribution of the property, with some people getting more than, some heirs getting more than the others, then in that case, it is very necessary that, because it is an arrangement as per your wish and not as per your operation of the law, it's advisable that you have a will made. Similarly, it could also be so that all fingers are not the same. Some are short, some are longer. The same way, you have some children who are better placed than others. So you may find that a particular child of yours needs greater attention, needs greater help, and needs to be provided for. In such case, you may leave a larger amount, or you may leave property in name of that child rather than of the other child. So it is not about only entitlement, but it is about a need, who has a need. Similarly, their ages could be different. So you might have a child who is already grown up, married and well settled, whereas you might have another child who is not yet married and is still studying. In such a case, you will probably make a different and a slightly larger arrangement for the other child than for the child who is already settled and has taken care of themselves. It's very natural actually for such things to happen. Now, one more thing, if there is a will, then in that case, the transfer of the various properties by the executor, obtaining the probate if it is required, or letters of administration or letters of succession, is something which can smoothly happen. Also, who will do all this process of identifying the legal heirs, understanding what you want to do, and executing it after your death? Those people are called the executors. So you can choose your executors, which is not possible if you die without a will. Then in that case, once an application is made for letters of administration, the legal heirs amongst themselves will decide who will do it, or the court will decide if there is no agreement amongst the legal heirs. But point remains that you will have ability, if you make a will, of choosing your executor. Hmm. Go to the next one. We'll go slightly faster. Then exclude those who you don't want to wish to bequeath. Often what happens is that there is some difference of opinion or there's a disagreement or something goes wrong because of which, you sort of do not, although member of the family, maybe your own child or some close relative, but you decide that, well, now that person is no longer in your life or relevant in your life, or you do not wish to give anything to that person. You don't wish that anything out of your estate ever goes to that person. Now, if that is such a situation, you can specifically exclude. In fact, I would say it is advisable to mention that rather than just omitting that person's name and not giving, because here there's a warning bell I want to put you. If that person is close enough, like a son or a stepson or anything, or a daughter, that legal heir can tomorrow, when the will is presented for probate or for getting the letters of administration, can claim that it appears that his or her name was forgotten by that person accidentally and not intentionally. So therefore, then what happens is that then there have been cases where arguments have been done in the court of law. Okay, my name was probably just forgotten. We tried to lead evidence of very people saying that we had excellent relations, this was there, that was there, and so on. And then suddenly, probably while making the will, he had a temporary lapse of memory and my name is forgotten. Now, to avoid this kind of a thing, there's a British saying, you might have even heard of it. It says, dismiss with a shilling. What does dismiss with a shilling means? That if you write that person's name and give a very paltry sum in the will, then in that case it becomes proven. In fact, you can even mention that I have already taken care of that person during the lifetime. I have done this and that and that, and therefore now you do not wish to give a large amount, you only wish to give this small amount to that person. So then the intention, see, because the will is not about whether it is equitable, whether it is justified, nothing of that sort. If you are able to convey exactly what is your wish in unambiguous terms, that becomes a will, and then howsoever unreasonable it may appear in terms of division of property, that is how exactly the property will go. So only thing is, you should not leave space open for the others to claim that either it was due to insanity or because you were medically unfit and not in a state of mind to make the will, or you did not comprehend what you were writing, or you have forgotten that person. So all these kinds of exclusions which happen normally under the Contract Act, those are the things which one has to take care of. That undue influence was not used. If somebody threatens you with a gun and then you write or make a will or sign a will, then that will is not valid. Although you may have actually put your signature to it, because it is using threat or undue influence or in some kind of an enticement, or so emotional or otherwise, some kind of a pressure on you to do it in a certain way. All these get excluded. But if you are able to show that, yes, you were in a good state of mind, you were in a disposing state of mind. That is what it's called. Disposing means you are in a state of mind where you could clearly convey whom you want the property to go after your death. If you are in that state of mind and lucid and alert, then in that case, whatever you write, even if it sounds unreasonable or is not according to law, not equal, not equitable, still it will be applicable and valid and accepted and upheld by the courts of law. You can also provide for charity or donations. The succession laws don't provide for this. So if you die intestate, then nothing of your estate will go for charity or donation. Similarly, one more very important thing. See, what happens is when you write or make a trust, the property irrevocably goes into the trust. So moment property goes into a trust, you have no control over it. So you cannot change it. Similarly, some people say, "Arey, मैं जिंदगी में gift दे दूंगा." Now, as a professional, I always advise my clients, ठीक है, even if some tax has to be paid, even if there is, what shall I say, the people are put to trouble after you, please do not part with your property till you are alive, whatever it may be, howsoever wonderful your legal heirs may be, and howsoever they may be looking after you, taking care of you. That is at least the piece of advice you all please follow for the purposes of tax planning or to save on something, or otherwise do not transfer property during your lifetime, because after your death everything is eventually going to go to them. So don't make that mistake as far as possible. So what happens then is, if you're making a will, then you can always change the will. No, because today you make a will on the basis of circumstances which you have. Possible that later on your circumstances change, new members enter into your family, or some people may exit from your family or your circle whom you wish to leave the property. So revision in terms of how much share or what quantum are you giving to which person, that is also possible. Now, under a will, tax planning is also possible. We'll briefly touch upon it as we go ahead. And of course, to get a sound sleep, because now you have done what you wanted. Now, there are certain limitations to the will. Let me warn you. At the same time, when we are looking at reasons for making a will, that to what extent a person can control from his grave or from wherever he is after the death has limits to it. So one cannot exercise unlimited control. So you cannot have, once you give the property to someone and that person gets the property, beyond that, what will he continue doing with it is only possible in a limited way, but not in a perpetual way. You can't forever keep dictating how your property is going to be used, how it is going to be this. Maybe you can put a condition that yes, a particular person will get a property if that person, if he's married, then he will get it. You can put that. But whatever you do, it must not be against public policy. So if you provide that, okay, if X does not, if X does not marry Y, then he will get it. No, something like that is not permitted. You follow. Anything which is against public policy cannot be a condition in a will. Even if you put it, then in that case, that condition will be treated as null and void. So ideally, I mean, generally the sane advice is that do not make any conditional will, ideally. But sometimes it is required to be made. For example, you want to leave property for your children, but you want that your spouse or maybe your parents or somebody who's there, who's dependent on you or who you have a special corner for, but is advanced in age. So ultimately giving property to that person may not actually be beneficial. So you could probably say that that person will have or enjoy the property during their lifetime. After their death, it will go to whosoever is the legal heir, the son or the daughter whom you want the property to go to. So especially for property, such a conditional bequest, it is called bequest because what you bequeath, that is what you give under a will, is called bequest. So that bequest can be done in such a manner that the life interest or the lifetime user and enjoyment and benefit can be given to one person, and after the death of that person, property may pass to another person. That can be provided. Now, in such a case, what happens is a limitation arises. The person to whom life interest is given cannot sell the property or cannot transfer the property. So that becomes a onerous condition sometimes. So it's not advisable to do that. So any condition always becomes onerous on the recipient of the bequest. Now, fine. I think we can now move to the next one. One second. Here. So what are the common methods of passing by the estate? We have already discussed that. One is under a will, and the second thing is where there is no will. There is no third way in which an individual's property will pass. So what is a will by definition? A legal declaration of a person's wishes regarding the disposal of his or her property or estate after death, especially a written instrument legally executed by which a person makes disposition of his or her estate to take effect after death. So first of all, what are the requirements of a will? So we will look at that because it is here stated that it is a legal document. So let us look at the essentials. So will is a written legal declaration document duly dated. Now it has been found often that wills have also been made on a bark of a tree. Tree bark. They have been made on different medium. Yes, but it has to be a written thing. So the writing need not be of the testator. If it is good. There's a question. Should I take it at the end or should I take it now? Sharma Sir. It's about, we'll deal with that. It is about whether the property is self-acquired or ancestral and can it be given under a will from father to son by will or family arrangement. That can son give away that property through will or his siblings have claim on it. We'll deal with it slightly later. Yes. So will is a written legal declaration duly dated. So there has to be a date. If it is undated, then it is not valid. So it has to have a date, a place where it is signed has to be also mentioned. Who is making the will has to be clearly mentioned. He has to be identified. And who are the persons to whom it is to be given should also be identified. So vague mention about somebody, my son will get and you have more than one son, or my child will get and you have more than one child, that can become a problem. So the person to whom you want to intend to give every part of your property should be clearly identified. In fact, often it is advisable to begin this way that you mention who all are the legal heirs. So, so you are so and so, your spouse is so and so, and your legal heirs are whatever, your spouse and your children. Who are these? At least your class 1 legal heirs should be mentioned. Who is the spouse and the children. Now, signature has to be there or a thumb impression. If a thumb impression is there, or even if it is a signature, it has to be in the presence of 2 witnesses. Now, again, remember that normally in the case of cities like Mumbai or anywhere where there is a high court, the will matters always go to the high court. They don't go anywhere else. Whereas if it is not this major 4 towns of Bombay, Calcutta, then your Chennai, or this residency towns, what they are called. So if it is not one of those, then it goes to the district court. It doesn't go to the high court. So, I mean, as you may have it, the language of the high court is only English by our constitution. So please remember that. So language of the high court being only English, if you have signed in vernacular language or the will document is in vernacular language, it will have to be got translated from the official translator's office, which is attached to every high court. So to ease things, ideally, if you are signing and if you are writing the will, it is best to do it in the English language. If the person who is writing, signing, etc. is not aware of the English language, then in that case, you will have to have a clause in it and somebody will have to interpret the will, and that person has to state clearly that yes, I have explained the will, and the person who is making the will also has to say that yes, the will contents are explained to me in my vernacular language and I have understood them. So that has to be conveyed. Every page, because one often feels, oh, I am signing at the end. No, that doesn't work, because then the intervening pages are not signed. So every page has to be signed by the testator. And the witness also, you should have initials, at least initials or full signature on every page and on the last page, because so that there is no risk or fear of interpolation at a later date. If the document goes to the forensic laboratory, then it can be established that all of them are signed. Because if one document is signed now and one document is signed, I mean, somebody replaces with the document or something, and of course that will be signed later, much later. It can be readily identified by using whatever the forensic methods and techniques. Now, one very, very important pitfall, a beneficiary should not be a witness. So person who is getting something under the will should never be made a witness to the will. Otherwise, that the will does not become invalid. The person, the beneficiary becomes disentitled to the bequest. Means whatever is written in his favor, that XYZ is going to his or her favor, is going to get this under the will, that bequest will become null and void. It will be as if that was never written in the will. Please remember this carefully. Okay. Then next you have, sorry, I'll quickly rush through this because these are just routine matters. Then you can ask me questions. Capacity, who can make a will? A person who is not below 18 years and is of sound mind and disposing capacity, not under undue influence either of a person or of an intoxicant or because of high fever, coercion or enticement. In short, or threat. So in short, free will is to be established. And what is the challenge normally? That old persons, infirm, seriously ill. So normally it is advisable that apart from the witnesses, a doctor writes there at the end of the will that I, Dr. So-and-so, personal physician or whatever of the testator or testatrix, that is the person who is making the will, have examined that person's name XYZ and found him to be in good health and in a sound and disposing state of mind. Sound means sound mind and disposing means in such a health and condition that that person can write the will. Basically, that is what it means. So, moment you have that, then it is difficult to challenge the will. Now, some people go ahead and do videography also. That is, a video recording of the entire proceedings is done. So, often either the person who is making the will or the lawyer reads out the will, is understood, and then that person signs and the witnesses sign and the doctor first examines and signs and everything is videographed. But let me tell you, whatever limits you may go to, always there can be challenge, because somebody may say that these audio video tapes are doctored and this and that. So just doing a videography or just registering a will does not mean that the will is foolproof or it is established. Even a registered will can always be challenged in a court of law. But the chances that it will be rejected as a false will are very slim if it is registered, because person as well as the witnesses go before the sub-registrar, who is a government official on duty, who ascertains that yes, is this your will, you're doing it with free mind. Or that person goes there, or the registrar visits your house, he sees your condition, so he knows. He won't register a will if a person is unconscious or if a person is not able to understand what is happening. So he asks him questions, finds out, are you so and so? Yes. Okay, are you making the will? So is it with a free mind? So all this is done. So therefore, it becomes very difficult to challenge a will that is registered. Now, what is the problem? Why people then often say that no, why to make a registered will? Because if you make a registered will, then you cannot change it by an unregistered will. It becomes difficult. So every time you have to go for registration. Now, what is the third aspect, essentials of a will? Self-acquired property can be given under the will. I think your question gets answered. Whose question? The particular gentleman who had asked. After September 2005, undivided interest of a Hindu co-partner can be given by will to other family members, co-partners or members of HUF after September 2005. So even if there is no partition which has taken place on the death, suppose I am a member of a HUF, I pass away today, it is after September 2005. Now suppose I am a member of the HUF and I have 1/4 share, because I am member, my spouse is member, my 2 children are member. So we are 4 members. So 1/4 is my undivided interest. I pass away, even if the HUF is not partitioned, because HUF continues. As long as there are multiplicity of people, more than one person's alive in the who are members of the family continues. It never gets dissolved. So that's a mode of succession, by the way. If you have an HUF, then as long as there are members in the family, now male or female also doesn't matter, because by the September 2005 legislation or amendment to the Hindu law, it is now held that a daughter is deemed to be a son. Very simple amendment is made. Daughter is deemed to be a son. The moment that is done, the daughter becomes a co-partner, daughter becomes entitled to be the karta, everything, all the rights flow. Remember, wife cannot be the karta. That is the spouse. Similarly, if it is the wife's HUF, because suppose she's a member of the HUF of the parents, and then she's the eldest, she becomes the karta of that HUF. Now, the husband will never be a part of that HUF. Leave alone being a karta, he will never be a member of that HUF also, because he doesn't belong to that family. Whereas by marriage, by virtue of marriage, the spouse, that is the wife, becomes a member of your family, and therefore she is a member of both the HUFs. The HUF of her parents as well as the HUF of the husband. But because she is not the daughter, in this case, where she is member of the husband's HUF, she cannot be the karta. She can at the most be a manager. But we are not on HUF just now. What we are on is that if you have a share in the HUF, that much you can give away by the will. You are permitted to do so. So there will be a notional partition which happens, and your share will go away to your legal heirs according to how you have distributed it in your will. So I think that answers that question. There was a question. I might as well finish that question here. I mean, complete it just now. Chat. What was it? Can property which is not self-earned or acquired be given through will? Yes. Whatever is your property ancestral, which you are entitled to, which your share, that much you can give on your death under the will. The rest of the property is HUF property, so everyone can claim in it. The rest, 3/4. So if you have 1/4 share, that much you can give away. In the above case, can son give away property through will? If his father died without making the will and he has just received the property as legal heir, in such case, can his legal heir challenge his wish? See, it is like this. Your facts are not very clear, but what I understand is that somebody inherited property from someone else. Now, if that inheritance is of the property, he becomes absolute owner. But if it is an inheritance of the HUF property, then entire property won't come to him. Only one, whatever is the share of the father will come to him. And that much he can give away. So nothing beyond that. Often, this point arises. I remember of a case where what had happened was a person had given another property. That is, there was a property belonging to the spouse. But the other spouse had mentioned in the will that after my death, the property should go to X. It was realized that that property is not belonging to that person who has made the will. It is belonging to the spouse. Now, in that case, it is not binding. So that property will not pass because the property doesn't belong. It's like saying, today I say that, yes, the Eiffel Tower, after my death, it should go to my son or to my daughter. It won't pass because that doesn't belong to me. You follow? So just a simple rule of thumb for whoever is thinking of joint family property, that share of the person in the joint family property belongs to that person. Earlier, it did not. Just clarify this a bit more and then we'll move ahead fast because we have what? Another, say, 10 minutes I can take?
Yes, sir. Sure.
Sorry? Yeah.
Yes.
Okay. 10 or 15 minutes. So I'll be able to complete my slides well. So now what happens is that if there is this property of the joint family, that is an HUF property. Now, earlier, every birth brought a person into the family and every death just erased his name before September 2005. So what happened was, if a person is born into the family, all the shares immediately get adjusted. So So if before the birth there are 4 members, all of them getting equally, moment 5th member is born, everyone's share becomes 1/5. That was the HUF. And if there are 4 members and one passes away, then everyone gets 1/3, the remaining of. So it doesn't go to anyone. Whoever dies, just cancel that person's name. Whoever is born, add that person's name. Now what they have done is, on the death, there will be a deemed partition, as if HUF property got divided and whatever belonged to that person who died will go to him and will go to his legal heirs. So only that much portion will go to the legal heirs. Remember this. Okay. Okay, fine. You can probably, I have my email ID at the end. You can probably ask me. I may be able to answer your question. So it's you won't be able to share all the facts and not advisable also to do it online. Then now self-acquired property can be given under the will. That is done. Now right of heir is by birth, but even child in a womb inherits. Please remember that. Similarly, when the HUF is reduced only to 2 members who are both women, even then it is acceptable if one is a daughter, there is a co-partner, but you didn't have a co-partner because a family can, or even if there are only 2 men, there is no female. In short, it's not a complete family. Then also, as long as there is multiplicity of people, that HUF continues, because you can always have another member by adoption. Remember that. So adopted child is also very much a part of the HUF. Okay. Now, other essentials. Oral wills are not valid except for Muslims, but must be proved if challenged. So only under Mohammedan law, oral wills are allowed. Now, Mohammedans can bequeath self-acquired property plus ancestral property. That is the difference. So under Muslim law, only born and living people are entitled. So there, though, it's even dicey. See, in the case of Hindus, if a person passes away, his legal heirs automatically become members of the family, the next generation. But that doesn't happen under the Muslim law. If a person passes away, then that person is not alive, means everyone claiming under him is gone. So that's a very dicey thing. If a person has 3 children and one child passes away, then the other heirs, the legal heirs of that person who passed away, they don't get anything. So just a peculiarity. Now wills essentials 5. Registration is not mandatory, but always advisable because it becomes easier to prove the will. Mention always as the last will and testament every time, but multiple updates are possible every time because it becomes clear that this is your last will. Now, codicil means if you want to change just one point, you get one. You didn't have a car, now you have purchased a car. So you want to say who you want the car to go to. You can put it as a codicil, which is a short addendum modifying some of the contents or clauses of the will. Keep the language simple. It need not be legal language. What we speak, just simple language like that. Only thing is, it should be capable of one unique meaning. Vague wills cannot be given effect to and are invalid. Okay. Legible if handwritten. Paper and ink should last sufficiently long. If it evaporates, you have a problem. Can be on plain paper. It doesn't require stamp paper. There are no charges for registration either. So prepare one original. Choice of keeping, you keep it in the bank locker, with the lawyer, family friend, almirah, safe at home, or in the office, wherever you feel. But people should be aware of where your will is, especially your legal heirs and your executor. Advisable to have list of assets, immovable and movable, attached to the will, although it is not mandatory because it makes things easier. Executor does not have a tough time locating your assets. Practically, composition and details of assets keeps changing. So whatever the list is only indicative in nature. It is never final. Because some of the assets you may sell off, some of the assets you may acquire new ones, and you may not find the time to revise your will. Available assets only will pass as per will. Those which are sold or disposed of are automatically excluded from the will. Now, conditions against public policy. Generally not advisable to grant conditional bequests. We have already dealt with that. Appointment, minor guardian in case of minor or unsound persons. You will have to appoint a guardian. So it will have to be mentioned in the will. That's so and so. But if you are not mentioned, court will appoint a guardian and take care of that. Now, exclusions from scope of will, you will have to clearly mention what are those properties not owned by the deceased at the time of death. So if you have gifted away something, then in that case, it will not be included in the will. Please remember that. Assets inherited. See, for example, what happens is movable property. You know, movable property you may give away on your deathbed. They are called gifts mortis causa. So, but then if someone claims gifts mortis causa, he has to prove with witnesses that yes, it was done. You know, for example, when I'm on the deathbed dying, I may say, "Beta, ye gaadi ki chavi rakh li." You know, especially in movies, they show that. Ye ab tumhari ho gayi. Now, even if I have written something else in the will, that car will still go to the person whom I have handed over the key because it is movable property and I have given possession of the property. There's money, currency lying. I say, take this currency, take this jewelry. All those are valid transfers of property. Remember that. So on a deathbed, especially a person gives away assets, then they get excluded from the will because you've given them away. See, what you give during your lifetime, either by document or by physical delivery, if it is movable property, even money. I give a check of 50,000 and transfer the money to somebody, then that will get excluded from the will because I have transferred it when I was alive. Property held as joint tenants. See, tenanted property also technically cannot be given under a will, but you can mention. What can you mention? What is under the law? See, this your Rent Control Act, Bombay legislation says that a person who looks after and regularly stays in the tenanted premises with the tenant is entitled to the property to be declared as the tenant after the death of that original tenant. So what people do is generally mention in the will that so and so, maybe relative or otherwise, is looking after me in my old age or whatever, is looking after me, staying with me regularly, and person will get the tenancy rights. But it is not because of the will, it is because of establishing the fact that he is staying there. So people mention that in the will. Now, important part is executor is appointed by the testator or testatrix to look after, manage, distribute, and transmit the estate by giving effect to the will. Generally is a person of confidence, trusted by the family, knows all the family members. So there is no problem. But better to have one of the legal heirs also jointly as executor along with that outside person. Also another challenge, if you make an elderly person whom you have faith in as the executor, chances are that that person will go away before you. Then what is the use? At the same time, if you make a very young person, then you may not have at that time know what kind of person that is. So you may not have faith in that person. No, not the same wavelength. So it's always a difficult task to identify and put a proper executor. Sometimes banks, financial institutions, some banks like Central Bank, Bank of Maharashtra, they have executor and trustee wing. So you can appoint them as executors, possible. A person of confidence trusted by the family, that is done, age sufficiently less than the testator. Now, what are the powers of the executor? Making application for and receiving probate or letters of administration or succession certificate from the competent court. That document, moment you attach, even if there is nothing else, just send that document, because when you take the probate, you make a list of all the assets in the property. So whoever receives that copy of the probate will say, "Acha, list mein ye hai." The bank will immediately transfer the money in the name of executor. Whatever, everything will get transferred in the name of the executor, or in whosoever person's name, the executor gives written instructions to the person holding that property. That happens. So power to collect and realize assets, even sell the assets, dues, outstandings, pay expenses, liabilities, and debts, keep an account and distribute the properties to the beneficiary. Normally an account of the administration of the estate has to be given in 1 year. Otherwise, you have to apply for extension of time to the court. And eventually, once you complete the process, you have to give the account. Now, witnesses, another very important. 2 witnesses are required. You have to put their name, address, and they have to sign. Younger than testator, so they survive, must know the testator well. Tomorrow questions may be raised whether the witnesses were really present and whether the will has been signed in their presence. So it is important that they remain alive when the probate is there. So they should be younger. Be able to make sworn affidavit or statement in court confirming proper execution of the will. So they shouldn't get flustered. They should know, yes, you know that person, where had you gone to sign the will, all that should be fresh in their mind. Administrator, why? Executor not appointed by testator, then the court will appoint an administrator, or the executor has died, or executor is unable to execute or not available. How? Appointed through letters of administration granted by the court. So one of the beneficiaries also can become the administrator. Applied by beneficiaries, legality of the will has to be proved in order to do this. Now there are 2 types of wills again, which one should be aware of. One is a joint will, that is 2 or more testators entitled to make a joint will. Now the property may be joint property and it could also be separate property. You can cancel at any time or even by the survivor. So one person passes away, the other can also. Often what happens that the husband and wife make the will together. Why do they make it together? It becomes easy because what one wants to say normally is that after my death, my assets should go to the spouse, and after the spouse's death, it should go to the other person. But you can't directly state that. Failing that, that is what you can write. So normally what do you write? That after my death, it should go to my spouse. And if the spouse is not alive, it should go to the children. That is how you normally write it. So if you make a joint will, it becomes much more easier. Because then in that case, if any one of them dies, the property remains with the other. And after the other person dies, it goes to the legal heirs, whomsoever are specified, which are identical. So both people don't have to make separate wills. So it operates only after both are dead. Till that time, the property remains of the 2 people. So suppose, imagine you make a joint will, one person passes away. Everything will now come to the spouse by virtue of the joint will. After the other person passes away, then it will go. That is why they have said a joint will can be cancelled at any time when both are alive, or even after one passes away, the other one can cancel it and make a fresh will. Because then there is nobody else surviving. If both witnesses pass away before the testator, actually, technically, it will be advisable to make a separate will. That is the reason is that later on, it may become very difficult to prove it. If it becomes difficult to prove it, then it may not be worth its while. Okay, so one sec. What is it? I think this is done. Now I will come to mutual will. Now that is a reciprocal will. I already explained what a joint will made by 2 people, like say father and son, would be a joint will, 2 or more testators. But when the 2 or more testators are husband and wife, it becomes a mutual will. Okay. So, sorry, where did we go? Now, what are the essentials? Application for grant of probate. If the person who has passed away has or made the will holds immovable property in presidency towns. There are 3 presidency towns, Mumbai, Calcutta, and Chennai. Then you have to apply for a probate in the High Court. Otherwise, you get succession certificate or even probate from district court. Deceased has left. So in Delhi, you will have to apply to district court. You need not apply to the High Court. And essential to establish a clear. But if a person dies intestate, then probate is not required. Then letters of succession or administration. Who can apply? Executor or legal heir. Brief procedure is calling for objections. Normally you apply to the court. There is a newspaper advertisement. There is a NOC you obtain from all the beneficiaries or waiver of notice. Then it happens faster. But still 3 to 6 months is the time you take for getting a probate. Okay. Now, intestate succession. It goes according to Indian Succession Act. For Hindus, it is the Hindu Succession Act. In Muslim personal law, that is Sharia. And structure and distribution predetermined who will get what. But it's complex. That is the only point. So, if a person dies intestate, who will get what is very much clearly specified under these laws, but you have to understand the laws and the implications thereof. So Indian Succession Act, whom does it apply to? Applicable to any person in India other than Hindus. Now Buddhists, Sikhs and Jains are considered as Hindus. Therefore, the Hindu Succession Act applies to them. To Muslims, till 1875, the Hindu Succession Act applied in cases where it was customary to do so. For example, Bohras and others, they followed Hindu customs and therefore Hindu Succession Act applied to them. I think somewhere pre-independence, especially I think somewhere in 1932, the British passed a legislation whereby only Muslim personal law applied to those who profess that faith, although the customary law may be different. So that you have to remember what is the date of death. And to persons, intercaste or religion married under Special Marriages Act 1954, there also Indian Succession Act applies. In short, if you have a Parsi, then Indian Succession Act applies in India. Or if you have somebody who's what shall I say, Christian, then an Indian Succession Act applies. Remember that. Now, if two Hindus married under this, that is the Special Marriage Act, then their personal law is applicable for inheritance. Remember that. But if they are of different religions, then Indian Succession Act applies. So intestate succession. Succession under Indian Succession Act, for example, Christian. On the death of a male, if left, what is left is wife and children, then 1/3 will go to the wife and 2/3 will be equally divided amongst the children, including any predeceased children. Predeceased children are not considered only under Mohammedan law. Now, if only widow and husband's relatives and no children, then 50% to widow, 50% to husband relatives. If widow and no children and no husband's relatives, then 100% will go to the widow. That is how it goes, because they are heirs of the first degree and of the second degree. See, husband's relative or wife's relatives are heirs of the second degree. Although there is a point that generally under all these succession acts, the wife's relatives don't get anything, which is actually not fair. Maybe an amendment will come in the future. Now, Hindu Succession Act, Hindus, Buddhists and Sikhs. Death of Hindu male. First property go to relatives specified in class 1. Who are they? They are class 1 heirs, means widow, that is children, widow or widower, children, mother, widow 1 share and others 1 share. So everybody gets 1 share. If there is no class 1 heirs, then upon class 2 relatives, that is father and others, his relatives, so your brothers, uncles, whatever. No class 2 heirs, then upon agnates, those related to another wholly through males, whether by blood or adoption. So if there is no agnate, then upon cognates, that is those related to another wholly through females, whether by blood or adoption. So that is the last category. Now, if a Hindu female dies, the first property will devolve upon husband, sons and daughters, including children of any predeceased son or daughter in equal measure. So everyone gets equally. Same concept. Secondly, upon the husband's heirs. If the husband has no heirs, upon her parents. Upon the heirs of her father. Lastly, upon the heirs of her mother. That's how it goes. This is sometimes perceived as slightly unfair. No, why her property should, spouse's property should go to the husband's heirs if the husband's property goes first to his parents, if the first degree heirs are not alive. But as of now, that is how it is. Now, this I think we have seen already. This one. No, this also we have seen. Now, what is Muslim personal law? It is applicable. There are different sets for Sunni and Shias. It is interpreted on the basis of Hadith. Hadith is the sayings of the Prophet which were written down, remembered and written down, but they are interpreted by those who are considered as able to interpret them. So they have an authority to interpret them. Now, estate of the deceased is to be distributed only after the payment of debts and funeral expenses. Women receive half of the share amount that the males get. Remember that. So you won't go into further details, but always remember that under Hindu law or under the Indian Succession Act, normally there is a division which is equal, whereas under Mohammedan law, every male member gets 1 part, the female member gets half part. Okay. Now, you need a succession certificate in case of intestate succession. It is issued under Indian Succession Act. beneficiaries to approach district court or high court within whose jurisdiction the deceased was living. And if he did not have any fixed place of residence, then wherever any part of the assets are located, you can apply. A court will issue a notice to all concerned, maybe a newspaper ad, and after satisfying all objections are taken care of, will issue a succession certificate. Now, nominees. So nomination will quickly deal with. I think I am towards the end. Another 3-4 minutes, if you permit me. So then we can have question answers. Sharma Sahab.
Sure, sir, sure.
5 minutes. So a nominee is a trustee in a fiduciary capacity. We have already seen this actually. So whatever he does, all actions he has to do for the benefit of the beneficiaries, and not at all, he's not the owner of the deceased estate. He's a caretaker at the most. Anyone can be nominated. There are exceptions. For example, family pension, you can only nominate the spouse. That's all. And if the spouse is not there, then the children. Nobody else is entitled. And yes, of course, the parents, if none of them are there. Lots of litigation. Also, one more thing, remember, if you have nominated someone and then you get married, so before marriage, all the nominations, what are there, they get cancelled. Please remember that. So anyone who gets married, you have to make fresh nomination. Otherwise, those nominations get cancelled and it will be as if you have no nomination. You may think that, oh, there is nomination, but that is not so. Because your capacity changes. After marriage, you become a married person. So you have now one more person whom you are sharing your life with. And so therefore, all those old nominations, they go away. Now, whether nominee, a trustee or not owner is legally bound to transfer to the legal heirs, and they can demand. If not paid, they can approach the court. So remember this. Now, why nominee? Nominee is required because if a person dies, money given to the nominee for distribution to legal heirs can be quickly done through the legal heirs. Automatic transmission is there. So no will is required, no death certificate is required. So if one of the beneficiaries or even a third party is a nominee, he can get the money transferred to his name and distribute it to the legal heirs. Then there's no need for litigation. So one, there is protection, because otherwise it will be a very tough task for companies when they are transferring shares or even otherwise to understand who are the legal heirs and then do a proper distribution. There will be a lot of litigation. Every company, every housing society will be pulled into litigation. So for ease of administration, the law has provided that if there is a nominee and if the society or the bank transfer the funds to the nominee, it is absolved from all liability. Okay, so there is no difficulty. Okay, if a single Hindu lady dies without will and her parents are not alive, no, it will go to her, the parents' heirs. It will go to her parents' heirs. No, mother's heirs come later. First, it is to the father's heir and then it goes to the mother's heir. Okay, fine. We'll now take questions. So just leave the questions for some time. So basically, the nomination is to reduce litigation. Okay. Now, status of a nominee, affirmation of court. Mr. Ghosh, I'll take your question. Just let me finish just 2-3 slides. The provisions of nomination is found under various acts. For example, LIC, gratuity, cooperative housing society, banks, companies. But the nomination does not create a title or interest in favor of the nominee, with certain exceptions. For example, in a policy, if you nominate, the money goes absolutely to the person whom you nominate. Now, if a will is available, but the nomination is not there, then you have to take a probate. If it is in presidency town or letters of administration. Without that, you cannot do. But some societies are allowing with an affidavit signed by all the other legal heirs and an indemnity bond signed by the person in whose name the transfer is happening, and they allow transfers. So there are some instances where some such thing is allowed. Now, what about negative bequest? So if there is a liability, if there is a debt, will it be inherited? So please remember this. Unlike under Mohammedan law, you can distribute property even before it is, even before all the debts are paid. Now, in that case, what happens? Or suppose there is income tax liability. Let me explain to you that an income tax notice is there and that comes after the person dies or even before dies. And there is a liability to income tax. Now, what happens is you will have to pay the liabilities of the person who has bequeathed property to you only to the extent of the value of the asset which has come to. So if a value of the asset which has come to me is 10 lakhs and liability which is claimed from me of the person who passed away is 2 lakhs, I will have to pay it. It may not relate to that asset. Please remember that. It may be any liability. Because see, the creditor or the department or whoever is recovering the debt can approach any beneficiary. They don't have to approach only proportionately and all that. They will catch hold of whoever is easiest to catch hold of and has the most prominent property, and they'll say, pay the money. Your liability is this, that out with reference to the outside world. Amongst beneficiaries, you can later on claim that, oh, they have so and so has recovered from me, please share it. But outsider, whoever claims, if you have that much money received from the estate, you have to pay. That is what it is. But if debt is more than the estate, then in that case, the debt is not required to be paid. Then that's over. Now, what are the taxation aspects? See, section 159 talks of legal representatives, how they will be assessed to tax. So after the death, you can continue to file the return as legal representatives till your estate is sorted out. See, often what happens is there are complex estates, lots of properties, transferring them takes time, 2 to 3, 3, 4, 4 years. If there are disputes, it may take 10 years also. I know of an estate of which is 20 years have gone by, still estate return is only being filed as an executor. So if there is an executor, if there is a will, it goes under 168. If there is no will, under 159, return can be filed for the deceased person as if that person is still alive. Now 47.3 says any property which is received under a will is not regarded as a transfer. So the recipient has to pay zero tax. It's a tax-free receipt for that person. Whatever you receive under will, there's no liability to tax. Now under 56.210, receipts without consideration deemed income from other sources, but not those which are received as under will. So anything which is received under a bequest or under a will or under gifts mortis causa, that is deathbed gift, they are not liable to tax. Earlier, there was a law which said that such estate, whatever transferring on the death, was liable to estate duty, which was very high. Highest slab was 85%. So people had to buy policies to pay the estate duty, because otherwise physically it was not possible. You would have had to sell the property to pay the estate duty. Now somewhere, I think VP Singh's regime, the estate duty is removed. In fact, you will be surprised, in countries like the US, there is death duties. So if there's some bequest received, you will have to pay some tax on it. But well, not the recipient pays tax, but not in India. Now, the holding period is, so suppose shares are transferred, then whatever number of years the person who passed away held it will be considered as your period of holding. So, even property, they all become long-term. Remember that. Now, there are some vehicles. I'll quickly, I think I just take maybe 2 minutes for this slide and we'll wind up. See, trusts are tax specific trusts. That is, if shares of beneficiaries are known, they will be taxed at the rate applicable to the beneficiaries. In case of discretionary trusts which are non-testamentary, that is not made by a will, that means the shares of the beneficiaries of the trust are not known, it is taxed at the maximum marginal rate. So 33% plus surcharge, 36% is the tax. So not advisable. Earlier, discretionary trusts were taxed like individuals, that is basic exemption and everything, normal slab rate. So some of the big business houses made hundreds and thousands of trusts by permutation and combination of settlors and beneficiaries. So the department then with one stroke removed this benefit. why are discretionary trusts required? See, it is possible that you don't know who the beneficiaries are when you make the trust, because people will get added to your family. Second problem is that some people may require more money, some people may require less support. So if you have a board of trustees whom you rely on, they can distribute that. So that is another method of succession. Create a trust and let the trustees decide how to distribute. But then if you have to pay maximum marginal tax now, because some people misuse that provision, that's not advisable. But there is one exception under section 164. If it is a discretionary trust made under a will, then it will be taxed at the normal rate. So for example, on 10 lakhs, you will pay only 1 lakh tax. So if that discretionary trust has income of say 20 lakhs, the tax payable will be some 3 or 4 lakh rupees. So it will not be 20 lakhs into 40% or 8 lakhs. So you can make one discretionary trust under the will where you can leave it to the discretion of the trustees as to how the income is to be distributed. So those who really need the money can be distributed that income. Correct. So I think we will stop here. So what are the pros and cons? Wills are more certain. Full ownership remains during the lifetime. Amendment possible. Smoother succession and tax planning. Here the problem is that claimants may kind of arise in a case of a will. Dispute may arise. Legal heirs may challenge. Segregation of economic and controlling interest not possible. May be subject to debt duties if reintroduced. So those are the disadvantages of the will. So trust is an option. So is HUF an option. I think we stop here. So if you have any questions, quick, you can ask.
Thank you very much,
Right.
Vishnu sir, for
I hope
sharing.
it was a very short this thing, but I was able to cover as much as possible.
And very simplified also, for layman people like us, we have been able to understand.
Yeah, I think Mr. Ghosh has a question.
Yes, I know.
Probably wants to give some comments.
You are welcome to ask that question.
Sir, yeah. Pramod sir here, sir.
Indranil ji.
Pramod sir here.
Yes, sir.
Yes, Pramod ji.
Yes, sir, Pramod.
Yeah.
Yeah, please.
Yeah. Will you throw some light on the nomination, sir?
Sorry?
Will, nominations, sir.
No. See, nomination is a matter of convenience, so that
Correct, sir,
immediately the property can be transferred to the nominee. But
right.
The nominee doesn't become the owner. So if
Right.
Many people feel, especially I come across people who think that you're not made a will, you're not specified who your assets will go to. They say, no. What I have done is I have various fixed deposits and various shares. So I have made the nomination according to whom I want it to that person to get. But the pitfall there is, suppose you make nomination in favor of one son, nomination of another bank account in favor of the daughter, third bank account in the name of another child, and later on they are unequal.
Yeah.
Tomorrow the legal heirs can claim that we want our equal share in all the property. So nominee doesn't become the owner. That's the judgment of the Supreme Court.
Right.
So nomination is just a matter of convenience.
Yeah.
But
So
ultimately, if you want to secure legal heirs,
so more than one nomination can be done. There could be 3
yes,
or 4
you can do proportionate nomination also.
Proportionately, sir. Yeah.
Yes, that is possible.
Thank you, sir. Thank you very much.
Right, sir.
Sir, you can ask a question.
Yes.
We are not able to hear you.
Okay, now I have removed my earphone. Can you hear me now?
Yes, you are audible now, sir.
Achha, see, I have one big doubt. See, I have 2 properties which is in Calcutta.
Okay.
And these properties are not my name. It is my mother's name.
Yes.
And mother is alive. And she has made a will, which copy is there with me. Right? One copy is there, scanned copy is there with me. And in this will, she has mentioned that one flat is for me and other flat is for my younger brother.
Okay. Is it specific?
Very specifically, she has mentioned for one property. In other location, the flat is joint holding with my younger brother and mother. And in that will, she has mentioned that her part will go to me. So is it a correct way?
No, let me clarify now. In the will, is the property clearly identified?
Yeah, property is identified.
Correct. So now, as you said, there are 2 flats.
Yeah.
One flat is in her single name, and one flat is in her
No,
name
no.
jointly.
No. You are not following. See, we had one ancestral property which my father made. So
Correct.
that he had given to builder, and builder has given 2 flats.
Correct.
Then out of that 2 flat, 1 flat in the will, mother has mentioned that 155 flat will go to me, and other flat will go to my younger brother.
Correct.
Right. So that is clear. But there is another flat where my mother is staying now.
Third flat.
It is another flat. Third flat.
Third flat. So third flat.
Here the joint holders are my mother and my younger brother. And
Correct.
in this will, my mother has mentioned the part what she is having, it will be given to me. So
Correct.
is it a correct way of doing?
Because see, now what has happened is, how many flats does she own? She owns currently 2 flats, one given to you, one given to your brother after her death. She owns the third flat, which in the third flat, she owns only half share, because the other half share is already belonging to that brother. So therefore, that half share is given to you entirely, so that ultimately 1 flat is yours, 1 flat is his, and 1 flat jointly both of you will have 50-50 share. So after she passes away, either one can pay the money of the value at that time of the flat to the other and take over, or you can completely sell it and divide the proceeds, or you can keep it and both can use it, whichever way you decide.
Okay,
but it is an equitable thing. It is equitable because 1 flat to each, and the third flat already, I mean, what you could probably suggest, but that again is an issue, because now in Maharashtra, the stamp duty has been increased. Calcutta, we have to find out. Probably, if she is staying there, she may not be comfortable doing it, but she could add your name also. She could add your name to the flat. Then in that
time it could not be done, because I am staying in Mumbai and it is in Calcutta. That is why.
So then now it has been given by a will. So unfortunately, that is what.
So that is one part, and second part is all of his deposit, whichever is there in savings bank as well as FD, etc. In the will, she has also mentioned that it will be equally distributed. Now, just now you said these type of movable properties cannot be mentioned in the will. I mean,
no, they can be. Sorry,
okay.
I'm saying they can be, but they keep changing character. So it is generally advisable that you can mention that all my movable property, 50% will go to my one son and 50% will go to another son. Then
there also there is an issue. There is also an issue in some of these FDs and FDs where my younger brother is joint holder.
See, there you have to see who is the beneficial owner. Don't worry about the name being there. Even in the case of the flat, because when the flat was transferred originally, his name was directly put. That is why he could be considered as half owner. But otherwise, in the bank account, in the FD, I may add names of people. But if that property is not belonging to them, the name is just added for the sake of convenience. That does not count. Only the first holder is what counts in a bank account or in a FD also. See, tax deduction is done only for the first holder. So the law recognizes the first holder, unless it is proved otherwise. There is, I think, there is a question from Ankita Thakur, I think.
Okay, fine.
If the property is in the name of great-grandfather, who all can ask for the share in that property? See, if it is undivided property and it has not been passed on and it is still in the name of the great-grandfather, then the legal heirs of the great-grandfather, if there is no HUF, then in that case, the legal heirs can ask for it. So his immediate legal heirs and the legal heirs claiming through him. So assume now, I am here considering that the great-grandfather must have passed away earlier and you all have not divided it till date. So today all the legal heirs, whether male or female, they can claim a share in the property. If both the brothers have died, okay, so the 2 brothers are the legal heirs, and daughter of one brother asks for property from another brother's son, Is it mandatory? See, it is like this. Now, if both the brothers have passed away, you have to identify who are the legal heirs of both the brothers. So, divide the property as if the two brothers are alive. Each brother's legal heirs will get equal rights. So, for example, one brother has 3 children who are alive and the other brother has 5 children who are alive. Just giving an example. Then half of the property will be divided between 5 and half of the property will be divided between 3, irrespective whether they are male or female. And if apart from the brothers, there was a sister also, then that sister could also claim, and therefore today that sister's legal heirs can also claim, because the property has not been divided before 2005. If this joint family property, ancestral property, if there is a division which has been done at some point of time and it has become individual property, then those legal heirs cannot claim. Otherwise, today, as after the amendment and the Supreme Court judgment, if the two brothers had a sister, then they would also be able to, that sister's descendants would also be able to claim. That's currently the law for HUF. Okay, so I think that takes care of that question. Anything
CA
more?
Pushpaji has that question. If the single Hindu lady dies without will and her parents are not alive, then it will go to her siblings. If parents are alive, then it will go to both the parents or only mother.
No, see, if parents are alive, then no, if the parents are alive, it will go, I think, let me just check. It will go first to the father, I believe. 1 minute. Hindu Succession Act, I will just take out that. Just give me a moment.
Sure.
Hindu Succession Act. See, intestate Hindu female. So she is the one who has died, correct?
Yeah.
1 minute. Single Hindu lady dies. So first, the property will devolve upon husband, sons, and daughters, including the children of any predeceased son or daughter. Are there any? If there are no children of predeceased son or daughter, so nothing, no legal heirs from this side, then upon the husband's heirs. So does husband have any heir? If
But
not,
you can unmute and
yeah, you can unmute and ask.
Yeah, I think.
No, is she there? She may have dropped
she's
out.
there. But
Okay.
as a lady is not married, she's saying.
Okay, 1 sec. Let me see. And who will be rightful owner of the property? That 1 minute. Before that, what is it? Lady is not married. Okay, fine, great. Then in that case, upon the heirs of her father first, and then the heirs of her mother. But if both the parents are alive, then they become class 2 heirs. So it will go to both of them. It will go to both of them if both are alive. If one of them is alive, it will go to the alive person. And if both are not alive, it will first go only to the father's legal heirs. And if there are no legal heirs of the father alive, then it will go to the mother's legal. So as long as parents are alive, it will go to the parents. That is clear. Because they are the next class of heirs. I think there is another question by Ankita. And who will be the rightful owner of the property that grandfather bought from auction? So does he have to share the property among his siblings? No, not the grandfather's siblings. See, what happens is, for the son of the grandfather, that is the two brothers, it is not ancestral property. But the moment the third generation steps in, that is the legal heirs of the brothers. See, there is grandfather. He has bought the property in auction. Grandfather's children. The grandfather's children. That is the two brothers. They are just legal heirs. But the grandfather's children didn't do anything. They didn't divide it. So the children of the brothers, for them it is ancestral property. So therefore, all the siblings get a right. That's the problem. Okay. Not a problem. I mean, that's the legal position. Okay. So I think now
I think one was that Mr. Sanghvi wants the full PPT. If you are okay, you
See,
can
what
share
you
it
could
with
probably do is, I have given the PDF
to BMA office, and anybody can access from there.
Yeah, use your I mean, just don't widely disseminate
No,
it
no,
or
no.
put it
It
on the
is
net.
only on the need basis.
Yeah. Okay.
Yeah. I think so. If there are no questions, I think thank you very much, Vishnuji, for spending time and explaining the all aspects so lucid and so simplified that people like us are also able to understand quite a bit of it. Thank you very much for
Thanks so
that.
much. Right.
And I'm sure for all the participants, this was a very enriching session. I thank our current executive committee members, our current president, Dr. Kavita Lagate, also to take out time to be here, and all the participants for attending this session, and also BMA Secretariat staff for making effort to organize this program. And special thanks to Mr. Pramod Shah, our senior colleague and the treasurer-elect for BMA for next year. Thank you very much, sir, for joining. So our next session will be next Friday, which is Management of Excellence, which is on 13th May. It will be taken by Professor Pradeep Khandwala, ex-IIM professor, and the session will be from 4:30 p.m. to 6 p.m. So we will request all to join, and all the participants who are not member of BMA, we'll request them to become member of BMA and enjoy the the offerings which BMA gives to all its members. Thank you very much for joining. Thank you, Vishnu sir, once again.
Yeah, I've given my email, so in case anyone has a query, you can put it on the email.
Sure, sure.
You not given your mobile number, sir.
Sorry?
Mobile number, sir, you are not given.
Can't hear.
Mobile number, sir.
Mobile number. Sir, I will
email is preferred because I am actually immediately traveling. I'll be going abroad. So I won't be taking any calls. So email is preferred.
No problem, sir.
Currently, right. Otherwise, it's there in BMA. So no problem.
Yeah. Pramod sir, I will give you.
Sir, okay, right, sir.
I know many advocates. I'm in the same profession, so there's no question.
Yes, no, not at all. No issue. I know you also for many years. You've been active in BMA for a very, very long time.
Dr. Vishnu, I'm former chairman of the Institute of Company Secretaries of India, sir.
Okay, yes.
Also corporate consultant.
Yes, I'm aware, sir.
It's a pleasure to listen to you, sir.
Yes, thank you so much.
I've been connected
with
BMA.
You found it useful enough.
Yes, sir.
And of some value. Because I tried to simplify it. It's always difficult. It's a very technical subject. It takes a long time to, difficult to cover it in a short span.
Right, I appreciate, sir.
So,
but there is a quotation, where there is a will, there is a way.
True.
Where there is a will, there is a way, sir. That's how it is.
No, thank you so much. Right. Okay. So shall I take your leave, sir? Sharma sir?
And the session is also available on BMA's YouTube channel. People can also refer to it at a later stage.
Yeah, because all the slides are there.
Yeah.
And, I've shown all the slides even in the session. So no issue.
Yeah. Thank you.
Right, sir.
Thank you so much.
Thank you.